A California tattoo artist is suing Daniel Keemstar Keem for $3.5 million. Let's get right into the lawsuits! It's a terrible Keemstar imitation. Viva Frei, Montreal litigator turned YouTuber, and it's another car vlog for reasons that you all know. I hope everyone out there is doing fine under these particular bizarre set of circumstances in which we are currently living. If nothing else, I hope you can learn something from these videos and they can distract you in these troubling times, but let's get into it. So what is going on? I'm sure all of you have heard of this guy named Daniel Keemstar Keem. He has a YouTube channel called Drama Alert. And the channel, as the name might suggest, focuses on drama in the YouTube world and in the world at large. He's being sued by one Nicko Romeo Lacoste, a California tattoo artist, for $3.5 million on the basis that Keemstar referred to Nicko as the P word on his YouTube channel. I have read through the lawsuit, and at the risk of being a Monday morning quarterback or a backseat driver or, the person who criticizes the work of others, I have some observations to make on it. Now, it's something I said in the past, and I'm sure you've all experienced the phenomenon. You will very rarely find a contractor who will compliment the work of previous contractors. Very rarely will you find a lawyer who will compliment the previous work of a lawyer in a file. Generally speaking, nothing makes someone feel more important than criticizing the work of others. And that is not my objective in reviewing, analyzing, and giving my feedback on these proceedings. I'm just going to go through them and let you know my thoughts. And in my humble opinion as a lawyer, I think this lawsuit is deficient on a few levels, but we're going to get into it when we get into the lawsuit. So let's get into the lawsuit! Again, terrible, just terrible. United States District Court, Central District of California, Nicko Romeo Lacoste, doing business as the California Dream Tattoo plaintiff versus Daniel Keemstar Keem, doing business as Drama Alert defendant. Complaint for damages for tortious interference with contractual relations and interference with prospective economic advantage. Request for injunctive relief. Demand for a jury trial. Jurisdiction. This court has jurisdiction under 28 U.S.C. Section 1332 because there is a diversity of citizenship and an amount in controversy greater than $75,000. Venue is proper pursuant to 28 U.S.C. Section 1331 because a substantial part of the events or omissions giving rise to the claim occurred in the district, and a substantial part of property that is the object of the action is located in this district. Plaintiff Nicko Romeo Lacoste is a citizen of California and resides at blank. Plaintiff's place of business, the California Dream Tattoo, is located at blank. Defendant Daniel Keemstar Keem is a citizen of New York and resides at blank. Alright, the addresses of the parties have been redacted because we don't really need the addresses. Suffice to say that the plaintiff resides in California and the defendant resides in New York. Yet the plaintiff has chosen the Central District of California to file the lawsuit. Typically, when you file a lawsuit, if there is no better reason, no overriding principle of law, you file it in the district where the defendant resides. So in theory, in this particular lawsuit, barring some other overriding principle, it seems that the proper jurisdiction would be that where the defendant resides, that being New York. Now, the plaintiff filed the lawsuit in California, which may raise some arguments on the proper jurisdiction. And it's not to say that the plaintiff lacks any potential arguments for why California might be the proper jurisdiction. They've alleged them somewhat. First of all, they have alleged that the federal court has proper jurisdiction because there is what they refer to as a diversity of citizenship, meaning that with respect to the parties of the suit, they reside in different states, and therefore because they reside in different states, the federal courts have jurisdiction. That and the quantum in dispute exceeds $75,000, thereby giving jurisdiction to the federal courts. When it comes to arguing why the proper venue is that of the Central District of California, the plaintiff argues that that's where the acts or omissions occurred, and that a substantial portion of the property that is the object of the dispute is located in that district. Now, we will get into it later on in the lawsuit, but we know exactly where this is going. The plaintiff is going to allege that the damages which occurred to his business, the tattoo shop, is located in California, therefore that is the proper venue. Now, it may not be a totally frivolous argument in law to say that we're going to defy the standard rule of where a lawsuit should be filed because the business that is affected by the allegations in the lawsuit is located in California. It may not be a totally frivolous argument, but it is an argument nonetheless, and probably an argument that is going to be had. If you're Keemstar, you're asking yourself, why on earth would I have to defend this lawsuit in California? I don't have any property in California. I didn't do anything in California. I live in New York. If this guy wants to sue me, he should do it in a New York court. And these are the types of purely procedural arguments that one typically wants to avoid in a lawsuit. They cost a ton of money, they take up a ton of time, and they don't actually contribute to resolving the underlying fundamental dispute. You can literally find yourself $20,000, $30,000, $40,000 and a year deep in a lawsuit, and you haven't even began addressing the substance of the lawsuit. You've just resolved the jurisdiction debate. If you're Nicko, the safe thing to do is to file the lawsuit in New York because chances are Keemstar would not move to change venue. If you're Nicko and you want to take a chance, you file the lawsuit in California and you run the risk of Keemstar coming to California and saying, no, this is not the proper venue, bring it to New York so that we can debate it there. Procedural discussion on proper venue aside, let's get into the substance of the lawsuit. Statement of facts. Drama Alert is a channel owned by defendant that is projected across multiple social media outlets, including but not limited to YouTube, Twitter, Instagram, and Snapchat. Defendant holds out Drama Alert as a platform to deliver what defendant prefers as news on the social media interactions in online entertainment. Defendant conducts interviews, publicizes publicizes videos and provides his opinions on the stories that he covers. Defendant uses these stories to push his own agenda and to sway his followers to sharing his opinions. Defendant has accused plaintiff of blank in several videos across the aforementioned social media outlets. Included in these are videos published to YouTube on March 16th, 2019, March 17th, 2019, February 10th, 2020. On February 10, 2020, defendant publicized a video recording of a conversation plaintiff was engaging in conversations of a sexual nature and an interview with the recording's creator. This recording was made by the individual with which plaintiff was engaging in the sexually charged conversation. This individual was a minor, hereafter known as Person A. Person A falsely told plaintiff that she was of a majority status. Plaintiff had no prior knowledge of the recording, nor had he given consent for its creation. On the date and time this recording was created, Person A was located in Florida, where she is believed to have been and still be a resident of the state. Person A transmitted this video recording electronically from her location in Florida to defendant in New York. The bottom line, Keemstar did a number of videos on Drama Alert where he referred to Nicko as a blank due to the fact that Nicko was apparently involved in sexual discussions with someone who was in fact a minor at the time. So Keemstar is reporting on facts that the plaintiff admits as true? Okay, let's just see exactly where this is going. Defendant used this video in his efforts to destroy defendant's business and reputation. Defendant has stated multiple times that plaintiff is finished, plaintiff's career is finished, and plaintiff belongs in a cage. Defendant has a demonstrable history for making accusations, notably other accusations of blank, which he is unable to substantiate, yet recklessly and maliciously continues to make such accusations. The accusations made against plaintiff have caused substantial damage to plaintiff's business. Plaintiff's business is a service-based industry, and the damage caused to his business is from an aggregate loss of a mass of individual clients. Defendant was acutely aware of the nature of plaintiff's business and the potential impact of his statements. Plaintiff and his business lost contract opportunities as a direct result of the controversy that defendant created to surround plaintiff. Plaintiff lost business as a result of employees deciding to pursue alternative places of employment, causing greater harm to the earning capacity of the business. Plaintiff's loss of business directly correlates to the origination of the videos that defendant created and publicized. Alright, so the allegations are to the effect that Keemstar has damaged Nicko's business by reporting on factual statements that Nicko admits are in fact true in the pleadings themselves. Loss of employees, loss of clients, damage to the business, etc., etc. One thing I find particularly interesting about this lawsuit is that Nicko is filing it in his personal name but claiming damages for and on behalf of his business. I am left wondering if the tattoo shop on behalf of whom Nicko is claiming the damages is a sole proprietorship, meaning it's owned by Nicko alone in his personal name, or it is in fact an incorporated company. If it is in fact an incorporated company, and to the extent that Nicko is claiming losses on behalf of that company, it seems that we might have the wrong plaintiff here. But Nicko is being represented by counsel, and I have to assume that the counsel has asked that question and filed the lawsuit on behalf of the right petitioning party. But if Nicko is claiming damages for and on behalf of a corporation, the corporation has to be the plaintiff and not Nicko himself. If Nicko's tattoo shop is in fact a sole proprietorship, meaning that it's sort of under Nicko's personal name even though it has a DBA for the purposes of business, then yes, Nicko can be the plaintiff to the suit. Nicko alleges that this underage person, Person A, made a recording of Nicko without Nicko's knowledge. He then specifies that Person A resides in Florida. Now, something everybody should know, but a lot of people are actually totally unaware of, you're not necessarily just allowed making recordings of your conversations with third parties without them knowing. Before recording a conversation in which you are a party without advising the other party that you are recording the conversation, you have to be sure as to whether or not you live in a one-party or two-party consent state. Now, incidentally, I've already done a video where I talk about the one-party and two-party consent state. I'm going to link that video right here. But the bottom line is that you have to know if you live in a one-party or two-party consent state, because in a two-party consent state, one cannot record a conversation even if they are a party to it without advising all other parties. In a one-party consent state, however, the person making the recording does not need to advise the other party that they are in fact recording the conversation. Both Florida and California are in fact two-party consent states, meaning that if somebody wants to record a conversation, they have to obtain the consent of all other people on that conversation. But even if that recording were made illegally, that has nothing to do with Keemstar. He is not the one who recorded the conversation. So regardless of whether or not that recording was illegally made by Person A, once Person A gave that recording to Keemstar, Keemstar had nothing to do with the legality of that recording itself. I am not certain if the illegal nature of that recording would render it inadmissible as evidence. We'll have to see if that argument ever comes up in this lawsuit. But the fact that that recording might have been illegally made by Person A has nothing to do with Keemstar. So the facts at issue here are not particularly complicated at all. Person A makes a recording, legal or illegal, with Nicko, and it is a sexually charged conversation between Nicko and Person A, who is a minor. Person A gives this recording to Keemstar. Keemstar does a bunch of videos on the subject and refers to Nicko as a blank. Nicko is now saying that Keemstar's coverage of the subject has caused Nicko and his business damages. Now let's briefly flesh out those damages. Count 1. Interference with prospective economic advantage. Plaintiff believes and alleges that defendant's conduct, as alleged above, disrupted plaintiff's prospective economic advantage in obtaining his previously consistent stream of clients and revenue. As a direct, proximate, and foreseeable result of defendant's wrongful conduct, as alleged above, plaintiff has suffered damages in an amount to be proven at trial. Plaintiff will seek leave to court to amend this complaint to set forth the exact amount of damages when they have been ascertained. And this is the interesting quirk in law of Nicko's argument here. Nicko alleges that Keemstar's conduct is wrongful in the lawsuit, lawsuit, but wrongful is a conclusion, it is not a statement of fact. Nicko does not allege in what manner the conduct was wrong, and this might be critical as relates to the two charges. My understanding is that interference with prospective economic advantage and interference with contractual relations requires an underlying tort. That is why Nicko has to allege that Keemstar's conduct was wrongful, but he doesn't allege in what way it was wrongful. In the Gibson's Bakery versus Oberlin case, there was an argument made for tortious business interference, but the underlying wrong was defamation. In that case, Gibson's Bakery argued that Oberlin tortiously interfered with business relations on the basis of the underlying wrongful act of defamation. Oberlin said Gibson's Bakery was racist and encouraged others not to shop there anymore. And so the underlying tort of the interference was defamation itself. In this case, Nicko has said that what Keemstar did was wrongful, but didn't explain in what way it was, in fact, in law. And while they're not arguing defamation, it seems that they might be suggesting it, but they are going to fail on a defamation claim. Nicko would necessarily fail on the defamation claim for two very big reasons. First and foremost, truth is an ultimate defense to defamation. What Keemstar said was factually true. Nicko engaged in a sexually charged conversation with a minor. The other reason is that statements of opinion that can neither be proven nor disproven typically are protected speech. So when it comes to Keemstar calling Nicko the big P, it is either factually correct based on the evidence or it is a statement of opinion, in which case it can't be defamatory. And as we have just seen in the Unsworth versus Elon Musk lawsuit, which was a defamation lawsuit based on the exact same accusation, Unsworth failed in that lawsuit. So while it seems that the underlying tort to which Nicko is alluding would be defamation, we know that he would fail on that claim. And so it's not even clear what the underlying tort to the interference with prospective economic advantage would be to justify that claim. Simply put, if stating a fact harms someone else's business, they do not have recourse against you for stating that fact. Count 2. Interference with contractual relations. Plaintiff believes and alleges that, at all times relevant herein, defendant was aware of and had knowledge of plaintiff's contractual relationships with promoters, agencies, and social media platforms operating on local, national, and international stages. Plaintiff believes and alleges that, by his unjustified and unprivileged conduct as alleged above, defendant intended to disrupt the contractual relationships between plaintiff and such entities. Plaintiff believes and alleges that defendant's conduct as alleged above disrupted the contractual relationships between plaintiff and such entities. As a direct, proximate, and foreseeable result of defendant's wrongful conduct as alleged above, plaintiff has suffered damages in an amount to be proven at trial, and which plaintiff is informed and believes exceeds the amount in controversy threshold for classification as a federal diversity jurisdiction case. Plaintiff will seek blah 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 blah. And here we see it again. Accusations for show, facts for dough. Nicko is referring to these acts as wrongful and illegal without describing in what way they are wrongful and illegal. It's a nice opinion that you find those acts to be wrongful or illegal, but you have to explain to a court in what way they are wrongful and or illegal. So not only does it seem that counts 1 and 2 are lacking the underlying crime or the underlying illegal act to justify those claims, Nicko has now gone on to ask for a restraining order, a preliminary and permanent injunction enjoining Keemstar to stop saying what he's been saying for the past little while. In other words, Nicko is seeking a court order to get Keemstar to shut up and have him stop saying facts that Nicko have admitted are true. Now that I fully appreciate the almost religious adherence to the First Amendment in the United States, I don't think I'm going out on much of a limb to saying that Nicko is going to fail on this claim. When it comes to the interference with contractual relations, it's nice that Nicko says, at large, Keemstar interfered with my contractual relations. But my understanding is that the interference has to be specific to contracts. The defendant so interfering with the plaintiff's contractual relations has to know of the specific existence of those contracts, and the interference has to be relatively direct. But just to say that by making certain statements of fact he interfered with all of my contractual relations, whether or not he even knew of those contracts, I think that is destined to fail on its face. But this is an interesting lawsuit. It is going to raise certain procedural questions, certain substantive questions, and I will be following it through. But I think it highlights a strategic mistake in that Nicko is not gaining any advantage by filing this lawsuit. By taking this lawsuit, he is only further publicizing his own potentially wrongful conduct. Nicko will undoubtedly argue that he didn't know how old this person was when he was engaging in the texts and conversations, etc., etc. But I don't think by this lawsuit he's doing anything to make himself look better or bolster that defense by admitting the essential allegations at issue. Another expression that I frequently like to cite, once you've stepped in the poop, stop walking around because you're just tracking it everywhere. From the facts, it seems that Nicko might have stepped in poop by his own conduct, but now he's just tracking it around by taking this lawsuit. He is making his own wrongdoing even more public than Keemstar made it. Anyhow, to be seen, I will be following it, but that is the vlog for today. If you like my videos and you like my content, please be sure to like, share, subscribe, hit the notification bell, and drop a comment in the comment section below. It feeds the algorithm. If you want to support the channel, all of the support links are in the pinned comment, but above everything else, support yourself right now, support your neighbors, support your friends and family through this difficult time. Stay safe, be well, have faith, and now you know your vlog. Peace out.